We are present this morning in the matter of State of Ohio versus Tyler Cran, aka Talia Cran. This is case number 24 CR 1412. Present open court this morning is the defendant with her attorney, Rachel Smith. We have had a couple hearings on this case, but we are here today for what I believe is going to be a change of plea, whereby the defendant is going to withdraw her previous enter plea of not guilty to the indictment in this case and enter a plea of guilty to two charges. The first being an amended count 1, amended to be attempted aggravated arson in violation of 2903.02a and 2909.02a2, that being a felony of the 3rd degree, and count 3 as indicted, grand theft of a motor vehicle in violation of 2913.02a1, a felony of the 4th degree. Count 2 would be dismissed pursuant to the plea negotiations. It's my understanding the defendant will enter a plea of guilty to those today and ask for a pre-sentence report. The state and defendant, through her attorney, have had extensive discussions about this case, mainly regarding sentencing. The state is amenable to an agreement of community control. However, at this time, there is no agreement as to sentencing, and all options are on the table until we see a pre-sentence report and have further discussions prior to sentencing.
Thank you. Smith, does that sound right?
Yes, Your Honor. My understanding of the agreement is consistent with that which the state has outlined on the record. I've relayed that agreement to Ms. Cran, and it's my understanding at this time that she does intend to enter a change of plea to count 1 as amended and count 3 as charged, with the understanding the balance of the indictment will be dismissed. I believe she'll be doing so in a knowing, intelligent, and voluntary manner.
Thank you. Were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here today?
Yes, sir.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to 2 charges here, and I'll go over those with you to make sure you understand what those are. The remaining count would get dismissed. We would defer sentencing to a future day so some evaluations could get completed, some reports, and come back at a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to this court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, sir.
Before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer so you could ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on here, right?
Yes, sir.
All right. Let's get started then. How old are you?
I was born December 13th, 1995, which makes me 29 years old.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, prior to coming into court here today, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medications, nothing?
No, sir.
Now, you would have been served with a copy of the indictment in this case. It's the document that sets forth particular charges you're accused of committing. Do you remember getting that?
I remember holding it in my hand, but I do not have it in my personal possessions. I believe it's in my...
I'm not asking if you have it with you right now. I'm just asking, do you remember getting a copy of that at some point?
Yes, sir.
And at some point you would have had a chance to look that over?
Yes, sir.
So in that indictment, you are charged with 3 counts, pleading guilty to 2. In count 1, I'm going to read that count to you. That's not what you're pleading guilty to. It's what you're charged with. It's alleged that on or about October 29th, 2024, in Madison Township, Lake County, Ohio, that you did by means of fire or explosion knowingly cause physical harm to an occupied structure, that being the residence at 6828 Middle Ridge Road in Madison Township. I'm sorry. That conduct constitutes the offense of aggravated arson. It's a felony of the second degree. Do you understand what you're charged with in count one? It's not what you're pleading guilty to, but it's what you're charged with. Do you understand that?
Yes, sir.
Any questions about it?
No, sir.
Now, for purposes of the plea today, the state has agreed to amend this count to a reduced charge called attempted aggravated arson. And what that means then is that you knowingly engaged in conduct that, if successful, would have resulted in the commission of the offense of aggravated arson. And it's a less serious offense. It's a felony of the third degree. There's a big difference between felony of third degree and felony of second degree. You'd be pleading guilty to the lesser offense, felony of the third degree. Do you understand the difference there?
Yes, sir.
Any questions for me about it?
No, sir.
Now, on count three, what's alleged here and what you're admitting to is on or about October 29, 2024 in Madison Township, Lake County, Ohio, that you did with purpose to deprive Bentley Todd Curran and Cheryl Ann Curran, who are the owner of property, that being a 2015 Honda CRV motor vehicle, that you knowingly obtained or exerted control over that motor vehicle without the consent of the owners or anyone else authorized to give consent. That conduct constitutes the offense of grand theft of a motor vehicle. It's a felony of the fourth degree. Do you understand what you're charged with pleading guilty to in this count?
Yes, sir.
Any questions about it?
No, sir.
Now, there is a second count of this indictment, a charge of arson that's being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
Any questions about that charge?
No, sir.
Well, then before I can accept your guilty plea to the two charges I just reviewed with you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, do have the right to have a trial in this case. And a trial could be to me as a judge, or I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then the jurors would make that ultimate decision. And that decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of each of these charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, sir.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio. He would have what we refer to as the burden of proof. By having the burden of proof, what that means is that it is his job. He bears the responsibility or the obligation. He bears the burden of proving you guilty at a trial before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since it's a criminal case we're dealing with, that burden is what we refer to as proof beyond a reasonable doubt. And that's the highest burden of proof there is in our justice system. And what that actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of each of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to try to do that, if we did have a trial, the prosecutor would be bringing witnesses to come into court to testify for the state and answer questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. She can ask them anything she wanted to within certain rules. Do you understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes, sir.
And you further can request this court issue an order. We call that order a subpoena. And what a subpoena would actually do is it would force or make someone come into court and testify on your behalf and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
You realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. I'm sorry, excuse me. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Lastly, if we were to go to trial and you were found guilty, you'd have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Do you understand a guilty plea is a complete admission of guilt? That means you're admitting to the facts being alleged by the prosecutor regarding these charges you're pleading to. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll first of all be found guilty by this court, and then you'll subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to 2 counts here. The lesser included charge of count 1 that you're pleading guilty to is a felony of the 3rd degree. This offense is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, or 30. So if I was to impose a prison sentence, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve for that count. Do you understand that?
Yes, sir.
Now, count 3 is a felony of the 4th degree. That's the theft of the car. That's punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Now, since there's 2 separate offenses here, if I do impose a prison term, I would impose a prison term on each count. And then as a judge, I have the discretion to run those prison terms either concurrent with each other or consecutive to each other. Concurrent means together. You serve both prison terms at the same time together. Consecutive means one after the other. You serve the prison term in the first count, whatever it is, complete that, then serve the prison term in the next count. You understand the difference there?
Yes, sir.
So in this particular case, if I was to impose the maximum prison sentence on each count and run them consecutive to each other, you're looking at a maximum possible prison term of 54 months, or is that 4.5 years in prison? You understand that?
Yes, sir.
Now, are you currently on probation or parole to any other courts or agencies?
No, sir.
Do you have any other charges pending against you right now anywhere?
Not that I'm aware of.
If a prison term is ever imposed, in this case, upon your release from prison, you would be placed on what is called post-release control, and sometimes referred to as parole. It's a period of supervision you would be on after you completed the prison sentence. In this case, it would be mandatory for the attempted aggravated arson charge, and it would be for at least 1 year, and it could be up to 3 years for the parole authority to determine that. You understand that?
Yes, sir.
And while on post-release control, if you ever violated any of the conditions of your supervision, parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50%, or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case. On the attempted aggravated arson, there's a possible fine of $10,000 or up to $10,000. On the grand theft of a motor vehicle, there's a possible fine of up to $5,000. Altogether, it's a possible maximum fine of $15,000. You can also be ordered to pay court costs. You can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, sir.
You could also be ordered to pay restitution in this case for any economic loss any victim may have suffered as a result of the criminal conduct you were involved with. Do you understand that?
Yes, sir.
Further, the time of sentencing, you will be classified as a an arson offender, and you'll be required, it'll be explained to you at that point what your obligations will be to register as a registered arson offender, and that will require you to register in person at the county sheriff where you reside once a year. Your personal information, name, social security number, where you live, etc. And I'll explain those in more detail at the time of sentencing when I'm required to do that. But you'll be required to do that annually. Was it for 10 years, I believe?
I believe that's correct.
You'll be required to do that annually once a year for 10 years. You understand that?
Yes, sir.
All right, now aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. It could be, strike that. You could also be placed on, let me start over. When I mentioned the possible prison term, I told you it was possible. Prison's not mandatory with this charge. You're eligible for probation or what is called community control sanctions. Do you understand that?
Yes, sir.
You understand that just because you're eligible doesn't mean you'll automatically be put on probation or receive community control. It means I'll consider that. If that's what you're asking for. It appears that you are. I'll look at all the information presented, and then I'm going to make the decision that I think is the right thing to do. You understand that?
Yes, sir.
Now, if you are put on community control sanctions, it could be for up to 5 years, and as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve time in the Lake County Jail of up to 6 months, the condition of your probation. Do you understand that?
Yes, sir.
Further, if you're on probation, you're violating the conditions of your supervision, we would have a hearing in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could impose more restrictive sanctions against you, or I could terminate or end your probation at that point and send you to prison at that point. And that could be for the period of time I mentioned before, up to 54 months. And that could also be consecutive to any other prison sentence you may be serving at that time for some other case, or that you're being sentenced to if there's some new case that were to occur. Do you understand that?
Yes, sir.
Lastly, when we do proceed with the sentencing hearing down the road, you're going to have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. She's allowed to recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes, sir.
You understand that whatever the attorneys say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along with that if I didn't think that was what should be done. You understand that?
Yes, sir.
All right, were there any questions at all about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to discuss this case with your lawyer and have her review everything with you, the reports, whatever issues there may be, answer whatever questions you have? Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has she or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today? Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering to plead freely and voluntarily?
Yes, sir.
All right, then, do you have any questions for me at this time regarding anything we've talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to talk with your lawyer before we go forward with your plea?
No, sir.
All right, then what's going to happen now is that the prosecutor here is going to explain for me what the facts would show in this case if we had a trial. I want you to listen to them because I'll have some questions for you about that, all right? Mr. Donnie.
Thank you, Your Honor. Before I read the facts, just one thing that I neglected to put in the change of plea paperwork was under Revised Code 2929.7.1 that the defendant could be subject to paying the reasonable cost of investigation and the process for that for the arson. So I don't know if that needed to be mentioned, but
Well, I will mention that. I thought that was the case, but it's not mandatory though, right? It's up to me to decide that.
it's the court is required to send out notice to the agencies, but then as far as what the court does with that, it is discretionary.
So you could also be ordered to pay the cost of the investigation in this case that occurred as a result of the arson. Do you understand that?
Yes, sir.
Mr. Downey?
Thank you, Your Honor. Had this matter proceeded to trial, the facts would have shown that on October 29, 2024, at about 3:42 p.m. in Madison Township, Lake County, Ohio, Madison Township Police and Fire responded to 6828 Middle Ridge Road for a report of a structure fire. When they arrived, they found it to be a single-family residence, which was actively on fire. That residence is owned by Cheryl and Bentley Coran, who are the defendant's parents. It was learned that Bentley had left to go to work and pick up Cheryl from the airport on that day, and they were on their way home when they received a call that their house was on fire. The fire was put out. State Fire Marshal determined that the fire originated in the basement, and it appeared initially at the time the fire was incendiary or intentional in nature. There were approximately $400,000 of damages done. As of today, the house is in the process of being repaired, but a completion date is unknown. Personnel on the scene also noticed, while putting out the fire, that Cheryl's 2015 Honda CR-V motor vehicle was missing, and that the defendant, who was also recently at the residence, was also not there. That vehicle was entered as stolen. At approximately 11 p.m. that night, the vehicle was located and stopped at the United States-Canadian border near Port Huron, Michigan. The defendant was attempting to cross into Canada and driving that motor vehicle by herself. The defendant was taken to custody in Michigan, was later interviewed by Madison Township Police and State Fire Marshals, where during that interview she did admit to starting the fire while she was at the residence alone and then leaving the residence in her mother's vehicle. This offer today, I just want to note for the record, was specifically approved by the Lake County Prosecuting Attorney Charles Coulson.
So were you able to hear what the prosecutor had to say regarding what he believes the evidence would show if we had a trial?
Yes, sir.
What, if anything, did he say about those facts as he presented them? Are they true? Did you do what he said?
Yes, sir.
Very well, then, regarding the lesser included offense of count 1 being attempted aggravated arson, a felony of the third degree, what is your plea at this time?
Guilty.
Regarding count 3, charging with grand theft of a motor vehicle, a felony of the fourth degree, what is your plea at this time?
Guilty.
I have in my possession right now a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just reviewed with you. Before I can accept your plea, I need to make sure you understand this document, what it says, and that you sign it here in court. My understanding is before I came out here, you had a chance to review this document, go over it with your lawyer. Is that correct?
Yes, sir.
Ms. Smith, is that accurate? Did you read this over with your client?
That is correct,
Review
Your
it.
Honor. I reviewed the document with her, and she indicated an understanding.
Is that correct?
Yes, sir.
So you understand what this document says?
Yes, sir.
Any questions for me about it?
No, sir.
It also appears that you signed the document. Did you sign it?
Yes, sir.
Ms. Smith, did you witness that?
I did, Your Honor, and I signed it as well.
Mr. Downing, you as well?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in court. Their attorney advised of all our constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of the lesser included offense of count 1, attempted aggravated arson, a felony of the third degree, in violation of 292302 and 2909.02A2, as well as count 3, grand theft of a motor vehicle, a felony of the fourth degree, violation of 2913.02A1. Count 2 will get dismissed at sentencing, but sentencing will be deferred. I'm going to order a pre-sentence report and investigation. Victim impact statement. Is there anything else you're requesting, Ms. Smith?
Your Honor, psychiatric evaluation, and we would ask that the client be assessed for NeoCap.
What was the first thing you said?
Psychiatric.
Psychiatric, okay. The psychiatric evaluation. Okay. Bond will be continued. Is there anything else for the record then at this time, Mr. Downey?
No, Your Honor, thank you.
Ms. Smith,
Not at this time, Your Honor.
thank you.
All rise. on 3 separate files. Files 25 CR 403, we're here today for sentencing. On file 25 CR 879 and 25 CR 1281, we're here today for informations. In the last 2 cases, it's anticipated by the state of Ohio that the defendant will waive his right to have his case presented to the Lake County Grand Jury, and furthermore to enter a plea of guilty to 1-count information on each file. Other than what's been spread upon the record, no threats or promises were made to this defendant to induce these pleas. Thank you.
Mr. Watson, does that sound accurate?
Thank you, Your Honor. I please the court, that is my understanding of this morning's hearing. On case number ending in 403, we are prepared to proceed with sentencing. And then on case numbers 879 and 1281, I have had a chance to fully pre-try those matters with the prosecutor. I believe full discovery has been provided. I've also had an opportunity to discuss each case with my client. He is prepared this morning to enter a change of plea by way of information on those 2 cases as outlined by the state. First, Your Honor, he understands that by entering a change of plea, he will be waiving his right to have these cases presented to the Lake County Grand Jury. Furthermore, Your Honor, he understands that by entering a change of plea, he will be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
Thank you. Mr. Hemming, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this morning?
Yes.
In regards to the 2 later cases, 25 CR 879 and 25 CR 1281, those are the cases that you have not yet entered a plea to. They represented to the court, they believe it's your desire to waive your right to have each of these cases presented to a grand jury. They're both informations, correct?
That's correct, Your Honor.
And to plead guilty to the charges in the information in each of those 2 cases, and I'll go over those with you to make sure you understand what those all entail. We would then adopt the pre-sentence report that was prepared in case 25 CR 403 and proceed to sentencing in all 3 cases. Is that your understanding of what the negotiations were between your lawyer and the prosecutor and what you want to do here today?
Yes.
Well, before I can accept your plea, I need to make sure you understand everything going on here. So what we're going to do first is have you enter a plea of guilty to the 2 new charges. If the court accepts that plea, we will then proceed to sentencing in all 3 cases. But before I can accept your plea in the 2 new cases, I need to make sure you, again, understand all the rights you have that you give up by pleading guilty, the penalties you face. You need to make sure you understand what it is you're charged with and pleading guilty to. So I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything that I'm asking you, if you want anything repeated or clarified, if you need a moment to speak with Mr. Watson and ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes.
All right. Now, the questions I'm going to ask you, I'm only going to ask you them once. They apply to both cases, though. We're not going to go through them twice. If there's anything that applies to one case and not the other, I'll make sure I point that out. I don't think that's going to be the case, but if that is, I'll let you know. But let's get started then. How old are you, sir?
43.
43?
Yes.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, did you receive a copy of the information that were filed in each of these 2 cases?
Yes. Yes.
And you had a chance at some point to look those over?
Yes.
All right, let's start off with what I have here. First, 25 CR 879. What's alleged here and what you'll be admitting to is on or about June 7th, 2025, in Paynesville, Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to this case?
Yes.
Any questions for me about it?
No.
Now, in case 25 CR 1281, it's the same charge, only a different day. It's alleged in this case and what you're admitting to in this case is on or about July 22nd, 2025 in Kirtland, Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. Again, the amount did not equal or exceed 5 grams, which makes this offense also possession of cocaine, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes.
Any questions for me about this charge?
No.
Well, now, before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, in each of these cases, have the right to have each case presented to a grand jury. So the charges I just read to you are part of what's called an information. An information is a criminal charge that's brought by the prosecutor's office without the case having been previously reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone here in Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well, but you can give up that right if you desire and go forward on the charges brought by the prosecutor and the information. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes.
Well, before I can accept your plea, I need to make sure you understand, I need to make sure you acknowledge that here in open court in writing, and I have in front of me 2 written documents. They're identical, except one for each particular case, with the appropriate case number on each one. And they basically set forth what I just explained about this grand jury process, and now you want to give up that right. Before I can go forward, I need to be assured you understand this document, and you sign it here in court. My understanding is before I came out here, you had a chance to review each of these documents with your lawyer. Is that correct?
Yes.
Mr. Watson, is that accurate? Did you review this with Mr. Hameen, answer his questions?
Yes, Your Honor, I did review each waiver of indictment form with my client. I read it, he read along with me, indicated he understood it, and signed each document, and I witnessed it in front of the prosecutor, Your Honor.
Is that correct, Mr. Hameen?
Yes.
So you understand what the documents, both documents say?
Yes.
Any questions for me?
No.
Did you sign both of these documents?
Yes.
Very well, then the court at this time will accept these waivers and make them part of the file in each respective case. At this point, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And you first off, in each case, have a right to a trial. And a trial could be to me as a judge, or I listen to all the evidence, and I make that decision whether you're guilty or not guilty. But you also have a constitutional right in each case to have a jury trial. And a jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence. Then those jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty of all these charges. Do you understand that?
Yes.
You understand by pleading guilty or giving up your right to have a trial in each of these cases?
Yes.
Now, if we did have a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome the presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since these are criminal cases, that burden is what we refer to as proof beyond a reasonable doubt. And that's the highest burden we have in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of each of these charges in each case beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least in order to try to do that, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that's called cross-examination. he could ask him anything he wanted to, within certain rules. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want. Do you understand that?
Yes.
You further can request this court to issue an order. We call that order a subpoena. And what a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
You realize you're giving up that right.
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. So what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes.
You further understand that if you did go to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will make it by accept your plea, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Do you understand a guilty plea is a complete admission of guilt? That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court and then you will subsequently be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, each of the charges you're pleading guilty to are felonies of the 5th degree, and each are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
And since there's 2 separate cases here, if I impose a prison sentence in each case, as a judge, I would have the discretion to run those prison terms concurrent or consecutive to each other. Concurrent means the same time, together, you serve them together. Consecutive is one after the other. You'd serve the prison term in whichever case, one of the cases first, whatever that is, and then you complete that and then serve the prison term in the next case. You understand the difference there?
Yes.
So with both cases, there's a maximum possible term of 24 months. You understand that?
Yes.
Now, I know you have the other case pending here. Do you have any other charges pending against you anywhere?
No.
Are you on probation or parole or community control or whatever, PRC at any courts or agencies?
Just probation.
Where are you on probation?
Here.
No, not yet.
No.
No, you're on probation.
You talking about the other case? You talking about that other case? The one that you already pled guilty to?
Yeah.
No, you haven't been sentenced on that yet.
Okay.
We held off the sentencing to do them all at the same time.
Gotcha.
So we're going to sentence you in that case right after this, along with the other 2.
So no.
So no other courts. You're on
No.
probation. Okay. I do know you have the other case here, and as I just said, we're going to proceed to sentencing in all 3 cases. I do, as the judge, also have discretion if I impose a prison term in that case to run that concurrent or consecutive with these 2 cases. You understand that?
Yes.
So with all 3 cases together, there's a maximum possible prison term of 3 years in prison. You understand that?
Yes.
Now, if a prison sentence is imposed in either of these cases that we're here for now that you're pleading to, upon your release from prison, you could be placed on what is called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you serve the prison sentence. And with these 2 cases, it could be up to possibly 2 years post-release control. Do you understand that?
Yes.
And if you were ever on post-release control and you violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall total or maximum, up to a maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentences I just mentioned, there's other sanctions that could be ordered. You could be fined in each of these cases. Each case carries with it a possible fine of up to $2,500. So it's a maximum of $5,000 between both cases. I could order that you pay court costs. I could also order that you reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable with any of these cases. Do you understand that?
Yes.
There's also a possible driver's license suspension in each of these cases, up to 5 years. I don't have to suspend your license, but I have the ability to, or authority to do that, I should say. Do you understand that?
Yes.
Okay. Now, a few moments ago, I explained the possible prison sentence you face in each case, maximum of 12 months on each case. But when I did that, I used the word possible because prison's not mandatory with either of these cases. You are eligible in each case for probation, or what we do call community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically get probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information presented to the court. Then I'll make the decision I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on community control sanctions, it could be up to 5 years, and as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes.
Further, if you're on probation in this court and you're violating the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions, including order that you serve time in jail, or I could terminate your probation and send you to prison at that point. And if I did that, again, that could be up to 12 months on each count, each case. It can all be consecutive. So with all 3 cases, 3 years, with 2 years and the 2 that you're pleading guilty to here right now. Do you understand that?
Yes.
That could also be consecutive to any other prison sentence you may be serving at that time if some new case arose or that you're being sentenced to at that time. Do you understand that?
Yes.
Lastly, at the sentencing hearing in this case, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf and recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just that. It's a recommendation. I don't have to follow that if I didn't think that's what should be done. Do you understand that?
Yes.
All right. Well, do you have any questions for me then regarding the potential penalties you face by pleading guilty here?
No.
You understand all the possible consequences?
Yes.
You still want to plead guilty?
Yes.
Have you had enough time to talk about the case with Mr. Watson and have him review everything with you and answer your questions?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, did any questions for me at this point regarding anything we've just talked about, what you're pleading to, the rights you're giving up, penalties you face? Any questions?
No.
Do you need any more time to speak with Mr. Watson?
No.
So what's going to happen at this point, then the prosecutor is going to explain for me, for each case, and we'll do one at a time, what the facts would show if we had a trial. I want you to listen to him, because then I'm going to have some follow-up questions for you about that, all right?
Yes.
Mr. Geigerich, let's do the 879 case first.
Thank you, Your Honor. The evidence would show that on June 7, 2025, the defendant was traveling in a vehicle that was subject to a traffic stop by the Paynesville Police Department at approximately 31 Fern Drive in the city of Paynesville, Lake County, Ohio. The defendant was the rear passenger. He was arrested on an outstanding warrant and search incident to arrest. Located a baggie in his right front pocket and a digital scale in his right front pocket. The defendant acknowledged to the police officers that the cocaine was his. It was sent to Lake County Crime Lab, where it tested positive for cocaine in an amount of 1.98 grams, and the scale tested positive for cocaine residue. I mentioned the scale because it's going to be voluntarily forfeited. Oh, that's it. Thank you.
Thank you. Mr. Hameen, were you able to hear what the prosecutor had to say regarding what he believes the facts would show in this particular case?
Yes.
What, if anything, did he say about those facts he presented them? Are they true? Did you do what he said?
Yes.
Very well, then, regarding count 1, charging with possession of cocaine and felony of the 5th degree, what is your plea to that count?
Guilty.
All right, Mr. Geigerich, let's move on to the 1281 case.
Thank you, Your Honor. The evidence would show that on July 22nd, 2025, the defendant was subject to a traffic stop by the Kirtland Police Department at State Route 306 in the city of Kirtland, Lake County, Ohio. The defendant was the sole occupant of the vehicle. He was found not to have a driver's license and driving under suspension. The defendant was arrested. A tow was requested. An inventory search of the vehicle yielded a bag with white powder residue in the center console and a straw with residue under the driver's seat. These items are sent to the Lake County Crime Lab where it tests positive for cocaine in an amount of less than 5 grams. Thank you.
Mr. Hameen, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show in this particular case if we had a trial?
Yes.
What, if anything, do you have to say about those facts as he presented them? Are they true? Did you do what he said?
Yes.
Very well, then, regarding count 1 in case 25 CR 1281, charging with possession of cocaine and felony of the 5th degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time 2 documents. They're both called a written waiver of guilty and judgment entry, and they set forth everything I've just discussed with you. Before I can accept your plea, I need to make sure you understand this document, each of them, and you sign them here in court. Again, my understanding is before I came out here, you had a chance to go over these documents with your lawyer. Is that correct?
Yes.
Mr. Watson, is that accurate?
Yes, Your Honor. I did, in fact, review each written plea of guilty form with my client. I read it. He read along with me, indicated he understood it. He signed it, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Mr. Hameen?
Yes.
You understand what the documents say?
Yes.
You have any questions for me about it?
No.
Now, it also appears in each of these cases that you signed each of these. Did you, in fact, sign them?
Yes.
Mr. Watson, you witnessed that?
I did, Your Honor.
Mr. Geigerich, you didn't sign this one.
Oh.
For the record, that was 879. All right, this time then the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty in case 25 CR 1281 of count 1, possession of cocaine and felony of the 5th degree in violation of 29-2511. I also accept the defendant's plea and find him guilty in case 25 CR 879 of count 1, possession of cocaine, felony of the 5th degree in violation of 29-2511 of the revised code. As in regards to each of these cases, I will incorporate the pre-sentence report that was completed in 25 CR 403 case, and that'll be incorporated into both of these cases. So with that done, Mr. Watson, is there any reason not to proceed to sentencing in all 3 cases at this time?
No, Your Honor.
Is there anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. Mr. Hameen has a drug problem, Your Honor, and I know he may not fully realize it. I know he may have downplayed it, as a lot of addicts will do. They don't think they have a problem until they get in trouble, until bad things happen. But Mr. Hameen recently lost his younger sister. and that really threw him over the edge. I know these 3 cases were essentially back to back. They were pretty close in time to each other. He has taken full responsibility for it. I mean, he's pled guilty. He wants to get his life in order. He's got family here today in support of him. Mr. Hameen knows that this court has a lot of discretion as to what it can do, but he's expressed to me that he would really like an opportunity at treatment. And I told him that it's not that he's just going to get out today and show up to a treatment center and go back home, that it's going to be, an in-depth process. There's probably going to be, inpatient or whatever if the court decides to go that route. And Mr. Amin told me, wonderful, that's what I need, that's great. He would welcome it with open arms. Judge, I don't think Mr. Hameen is an evil, bad person. I think he's actually a good person who's got a serious problem. And I'm hoping that these series of events are a true wake-up call for him. I know his history may not indicate that he's amenable to community control, but I think his attitude now will show the court that he is, if the court gives him that opportunity. He knows he's facing a lot of time in prison. The court made it very clear just now. But I think if the court gives him that opportunity, he's going to show the court that he can do what needs to be done and stay sober. I'm respectfully asking the court to take that into consideration. Thank you, Your Honor.
Thank you. Give me 1 second, please. Mr. Hameen, you have the right to address this court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes.
Go ahead.
I'd like to say I take full accountability for my actions. And I understand I have a drug problem. Not that it's an excuse. But a couple of days before my change of plea court date, my little sister passed. She was a twin. She passed, giving birth to twin boys in Arizona. Well, like anyone else, when they get bad news, I got low. It resorted to
You can sit down if you'd like. It's easier.
You okay?
it resorted to me using. I know it was wrong. I know it was wrong for me to do so. And they resorted me in jail. I also like to let you know I didn't take your gift of probation for granted or to upset you by any means. I was in pain. I apologize. And I'm confident I am confident I can overcome this problem with my support system and law help. I also have a job waiting for me if you could find it in your heart to give me another chance at probation. And I can show you the change that we both want to see. Thank you.
Thank you. Mr. Watson, anything else you'd like the court to consider?
No, Your Honor.
Mr. Geiger for the state of Ohio.
Thank you, Your Honor. The state of Ohio would trust the court to fashion a sentence that's appropriate in this matter. And, the thing I would point out to the court that case 1281 was committed while on bond in 25 CR 403. Thank you.
It was on both cases, wasn't it?
I think this one, he was arraigned, it happened 2 days before.
No,
he was
what I'm
arraigned.
saying is he was on bond in both cases, wasn't he? The
No.
last one happened in July.
Yeah, oh yeah, in both cases, yes, Your Honor.
So he was on the municipal bond in 879 and then this one, right?
Yes.
This court reviewed the pre-sentence report and investigation. I've considered the drug and alcohol evaluation that was completed. I've considered the facts and circumstances of each of the 3 cases, the nature of those offenses. I've considered what's been said here today by Mr. Hameen, his lawyer, prosecutor. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually indicating it's more or less serious. So the recidivism factors, the court notes in each of these cases that the defendant does have a criminal history. In case 879 and 1281, strike that. In case 1281, he was on bond both to this court and the Willoughby Municipal Court at the time he committed the offense in 1281. That's the Kirtland case. He has not responded favorably in the past to previously imposed sanctions. He's been on probation to this court before in the past. He's violated his probation a couple of times. Ultimately, he was sent to prison for the second violation. In regards to the drug abuse problem, there's certainly a drug abuse problem that relates to the offense. And he stood up here today and said he has a problem. When he went to the probation department, he denied having any problem. He said, you didn't have a problem. You were using cocaine at some point daily. Then it dropped down to 3 days a week. You say that's not a problem. You've been using it for years. You've gotten in trouble before in the past because of it. You were using it still and possessing it while you were on bond. Condition of your bond is that you don't do that, and you did it. Now, either you got a problem that you can't help yourself, or you don't care what a judge says, and you're going to do whatever you want to do. But you deny you have an issue. So you didn't today, but up until today you did. What was that all about? You at the probation department telling them that you didn't have a problem with drugs. Why'd you tell them that?
I told him.
You told them that you used drugs. I'm not saying that. You did. You told them that you've used drugs, and then you're at the point I think when this happened. The time was 3 days a week prior to being arrested. You told them when you last used, which I think was right before you got arrested. But when asked if you thought you had a problem with drugs, you said no, you didn't think you had a problem with drugs.
I'm pretty sure I said I had a problem with drugs. I didn't say I was open to treatment.
Well, other factors indicating recidivism is more likely. Again, the defendant violated conditions of his bond and both picking up new offenses as well as testing positive for cocaine, not providing a sample at the time of his interview. There's no factors indicating recidivism is less likely. Under 2913B1, defendant has previously served a prison term which overrides the presumption for probation and allows the court to impose a prison sentence without making any findings that are necessary to overcome any presumption. When I consider the whole history here, prison is consistent with the purposes and principles of sentencing. The question is, Mr. Hameen, whether you're amenable to community control sanctions, meaning whether you're able to and willing to follow the rules, comply with the conditions that are imposed, and do what you need to do to try to get back on track. You didn't succeed last time you were in front of me when we did this. But I'll give you one chance to try again. But it's gonna be a short leash because we've already done this before. I'm gonna get you treatment that I believe is necessary and will be helpful. Whether you take advantage of that and focus on it, put forth the effort that's needed, or whether you're just there to check off a box of what's required for you to do on probation, we'll find out. But if it's the latter, if you're just there to satisfy a condition of probation, you'll be back here pretty quickly because it'll show you don't care. If you do care and put forth the effort, then maybe it'll help you. And that's what we want. That's why I'm doing it. Maybe get you back on track. So I'm going to find that you're amenable to an available community control sanction for each case. In each case, you're going to be on community control sanctions for 2 years. It'll be concurrent, so it's just 2 years total for all 3 cases. In case 25 CR 403, I'm going to order the defendant serve 60 days in jail. Well, let me strike that. I'm going to order that he serve 150 days in jail. He has credit for 84. The other 2 cases, there's no jail time. I'm going to further order that upon a bed becoming available at NeoCap, the defendant be released from the jail. And in all 3 cases that he's ordered to enter NeoCap and successfully complete that program. So I've given an extra cushion of time, but whenever a bed's available, you're going to be released. If it's, I don't know, how long is the wait? Usually about a month.
Roughly a month.
Yeah.
3 months.
If it's next week, you can get out. If it's 2 months, you're going to get out. So whenever that bed's available, you'll be able to be released. The balance of that jail time will be vacated. You're to enter NeoCap and successfully complete that program and follow all their aftercare recommendations. Upon completing NeoCap, I'm going to order, in case 25 CR 403, now you're probably not going to have to do this, but I'm going to order that you return to jail for 30 days for the transitional day reporting program. Again, good chance you're probably not going to have to do that 30 days. But what that is, it's a program that helps people make the transition from being locked up for a while to being on their own. Sometimes when people get released from custody after being in for a while, you know, they're told to leave and they have nowhere to go. They don't have housing set up, they don't have work set up, and they need help making that transition. And it's a good program for those that need it. But if you have housing set up, if you have work set up, and it's something you can get set up and work on while you're at NeoCap, if all that's taken care of, I'll vacate those 30 days. You won't have to do it. But it's a good program for people that do need that help, so I put it in place for everybody that goes to NeoCap.
And that's only on 403.
That's only on 403. So the jail time being imposed is just on 403 in both. Upon your release from NeoCap, then, again, the following conditions, and this is for all cases. You're not to use any drugs or alcohol. That includes no marijuana, nothing. You should submit your random urine screens. They must be negative. A positive screen will be a violation. You can't tamper with the urine screens. Bring in fake urine, anything like that. You attend 3 AA meetings a week and have a sponsor. To obtain and maintain full-time employment, you need to get a job and you need to work. You need to keep yourself busy once you get out. In case 25 CR 403, I'm going to fine you $100. Repair court costs and supervision fees.
Your Honor, I think the $100 was restitution. No?
I'm ordering a fine of $100. He didn't plead a theft offense, and I can't order restitution to narcotics agents for that. There's case law on that.
Okay.
So basically, once you get through a NeoCap, just don't use drugs, follow their aftercare recommendations, and work. That's what the plan's going to be. Kelly, is there anything else I'm missing here I should think about?
Your Honor, I'd like to consider one doctor, one dentist, sign releases.
Yeah, I don't think that's necessary here.
No releases to be signed?
Well, I'm not ordering the one doctor, one dentist.
Okay.
But well, I'll sign releases for counselors and that. Yes.
Thank you.
Sign whatever releases they need in terms of being able to speak to your counselors. I thought you meant for the one doctor, one dentist. I'm sorry.
Okay. Thank you, Your Honor.
Anything else?
No, Your Honor, thank you.
So, Mr. Hermine, you understand the conditions of your probation?
Yes.
Let's do this for the record, just so the record's clear and it'll be easier. Hopefully you don't have to worry about it. In 1281, I'm going to order that he serve 58 days of jail with 58 credit. Just so the record shows. In case 879, 3 days of jail with 3 days of credit. So it's no more jail time, it's just the time you've already served. Basically giving you the credit for that. I need to advise you that if you fail to comply with any of the conditions of your probation, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, you can extend your probation in each case up to 5 years. You can impose more restrictive sanctions against you, or I can terminate your probation and send you to prison. And if I sent you to prison, in each case it would be 12 months. Each case would be ordered to be served consecutive to each other for an overall total of 3 years in prison. So that's what's hanging over your head. You understand that?
3 years.
Total of 3 years with all 3 cases. 1 year on each case. And all 3 would be consecutive. So it would be 3 years in prison is what's hanging over your head if you violate your probation. You understand that?
Yes.
And for the record, that would also be consecutive. It could be consecutive to any other prison sentence you may be serving on some new case you pick up, or you're being sentenced to at that time if that were to happen. You understand that?
Yes.
All right. Mr. Geigerich, I'll order the voluntary forfeiture of any contraband or meaning drugs or paraphernalia that were seized. Anything else, Mr. Geigerich?
Just so it's clear, for the remaining files, besides the jail time credit, you're starting with the no drugs, alcohol screens, 3 days a week. So the NeoCap has nothing to do with the 2 new.
No, NeoCap has to do with all 3 cases.
Oh, okay, all right.
No,
got it.
NeoCap is, the only thing that's specific to 403 is the 150 days of jail and the TDR.
Perfect.
Everything else is all 3 cases.
Got it, thank you.
You want to say anything else?
Nothing further, Your
All
Honor.
right, thank you.